And we are live. Hello, everyone, and welcome to another episode of Translators on Air. My name is Dmitry Kornyukhov. I'm your host. Joining me today, my incredible co-host, Elena Tereshchenkova. Hi, Elena.
Hi, guys.
And our guest today, Paige Dygert. Hi, Paige.
Hi.
Paige is an attorney with over 20 years of experience working as an in-house counsel for companies ranging in size from Fortune 100 companies to 50-person startups. Paige began using her language skills to perform Spanish and Italian translations in her daily work as an attorney. And in 2015, she decided she had enough of this corporate life, and she moved to Italy, started her own translation agency, and she's currently the founder and managing partner of Online Legal Translations, which collaborates exclusively with lawyer translators to perform legal translations. In today's episode, we're going to be talking about various types of agreements and contracts that exist between you and your customers, whether or not we should sign them, and what can be the possible implications of us signing these agreements. But before we jump to the topic of our conversation, I would like to make a few announcements. As always, the 5th season of Translators on Air has been sponsored by our friends at SmartCat. SmartCat offers a great translation tool and a platform where you can find more work, collaborate with other translators, and connect. So if this is something you're interested in, check out SmartCat by clicking the green button below this video. Or if you're watching this or listening to this in the description, just visit the first link in the recording. I've seen a few questions posted about the GDPR. Unfortunately, this is not the topic of our today's conversation. It's a bit outside of our scope. So for those of you who are interested in this new legislature in European Union, I have posted a link to the upcoming webinar from SiteGround. It's a hosting company. And they're going to be having an online webinar tomorrow on the same platform. And if you go to the chat window on the right-hand side and scroll up a little bit, you'll find this link because a lot of people are interested in this new legislature. People are asking questions what implications it will have for us translators. So I suggest you check out this webinar that's going to happen tomorrow. There's also going to be a recording, and there's going to be a lawyer who will be answering questions that are specific to this topic. All righty. I can see a few people tuning in. Welcome, everyone.
Hello. Hi, Sharif.
Hello, Sylvia, another Sylvia. Hello, Tanya. Hello, Sharif. Dmitro, Mar, Luis, Maxine, Ismarie, Amaya, Tracy, Steven, and Elisabetta. Thank you so much for tuning in, guys. I apologize if I mispronounce some of your names. Things happen because we have quite an international crowd here. For those of you who are watching this for the first time ever and have never participated in our webinars, let me quickly explain how the thing goes here. This is a live webinar. You can participate in the discussion by posting your messages on the chat window on the right-hand side. Or if you have a specific question in mind, and if you want Paige, Yelena, and me to answer a question, you can use the Ask a Question tab below this video stream, where you can post your questions, or you can upvote the questions that already been posted there if you really want us to answer them. And of course, these webinars are best enjoyed with friends and colleagues. We still have a few spots left, so we would really appreciate it if you could quickly go on your favorite social media, grab a link for this webinar from your browser window and share it and invite your friends and colleagues to join us, because more people, more fun. All right. I hope you enjoyed this webinar, everyone. Okay, Paige, over to you. How are you?
I'm great. How are you guys?
Pretty good, pretty good.
Good. Well, I keep hearing a lot of questions about NDAs, non-competes, non-solicitation. And by the way, I'm going to be referencing my notes,
yes,
so
yes,
I apologize
absolutely.
for looking down. But we have a lot of material to cover, so I hear a lot of questions. And, you know, if you're not a lawyer or practicing in that field, it can be a little bit confusing, but it doesn't have to be. So I wanted to share a little bit with you guys, you know, and talk about what is it all about? Should I care? What are these terms? Should I sign these things? You know, how long am I obligated under these things? And so before we get to that, I have to give you my standard lawyer disclaimer, which is that this webinar is not a substitute for an attorney, a law firm, or any other advice, opinions, or representation. I'm not providing legal advice, opinions, or representation. All examples are for illustration purposes. They're provided out of context and may not be appropriate for any particular situation. So now that we've got that aside, about me, again, I'm a 20-year in-house attorney for companies like Bacardi, Perry Ellis, and some little startups. I have a background in managing legal issues for big and small companies, but I'm going to be speaking to you from the context of me starting up my own business. It's online legal translations. I started in 2015, and again, that's the context I'll be speaking from. So, really just think of me as a colleague. Now, I'm also going to be discussing really US rules, but in contract law, they're pretty similar all over the world. So a lot of these concepts are going to be applicable in many places, and it will just give you an overall understanding of how it works. So one more thing before I jump into the terms is I use the terms contract and agreement interchangeably. So just remember that and don't worry about it. Don't be like, oh my God, what is she talking about? I thought she said it was a contract. I can't stop myself from switching back and forth. I wish I could, but so don't worry about it. They're both the same thing. So we're going to talk about a few phrases. One is confidentiality, one is non-disclosure, one is non-compete, and one is non-solicit. And I hope you come away with from this with a little better understanding of what these are, which ones may apply to you in your translation business and which ones may not. So these phrases really have no fixed legal meanings, believe it or not. They're kind of what you want them to mean or what your contract says. Other phrases like burglary or fraud, they're defined in statutes, in laws and codes, and they're defined further and explained by common law, which is cases that establish and clarify definitions. But these things are just terms that we throw around, and they're what we mean, what we want them to mean when we sign or write a contract. So basically, they're used to describe agreements or sections of agreements. So you're going to have like a non-disclosure agreement, or you may have a confidentiality section of an agreement or a non-compete section. So they're really just kind of ideas and not like, this is my confidentiality agreement. You may have a non-disclosure agreement, which I'll get into in a minute. So, don't be misled by titles that say this is a confidentiality agreement or this is a non-disclosure and think, okay, I know what that is, I can sign it. You really should read it, make sure you understand it before you sign it. It's what's written in the agreement that matters, not the title or even the titles of the paragraphs. In fact, a lot of agreements will have a whole section that says the titles of the paragraphs don't matter. It's really what's inside them. I mean, I would never have a contract that was so shady that I had to do that, but I see it a lot. So, okay, so anyway, I'm going to talk about how these concepts are generally understood and how they're used. But again, the actual agreement that you sign is what's important because that's the part that's enforceable. And what do I mean by enforceable? That means if one side of a contract doesn't fulfill their promises, the other side has a legal remedy. A legal remedy is, what can you do if somebody breaches the contract? They promised they wouldn't disclose my secret recipe, and now they have, and they've sold it. What can I do? You have a right to sue them in a breach of contract. There could be an automatic remedy under the law. That's more common in like a consumer agreement. We're talking business to business for the most part here. Other remedies that you could agree to in an agreement like this is liquidated damages, which means it's like a set amount written into the agreement that you would have to pay. Like if you give up our secret recipe, then you have to pay $1 million or something like that. So that's liquidated damages. Now, going back to the common understandings of these words, and just to give you the briefest overview to kind of get your head around it, confidentiality is a broad concept, and it really encompasses secret information that needs to be kept secret. Non-disclosure is like, don't share information that we give you. That's the confidential stuff. Non-solicit means don't steal our workers or don't steal our clients. And non-compete is don't learn from us and then go work for our competitors. Okay, so the obligations, they might be encompassed in a standalone agreement or a clause in a broader agreement, which we talked about a little bit. And the broader agreement could be your translation services agreement, which I'm sure many of you have signed, and you probably have your own standardized one. You may have to sign both a preliminary NDA agreement, and then a service agreement as well when you enter into an agreement with a company to do work for them. And I'll explain why. Everybody good so far?
Yep.
Yes.
Okay, looks good. Okay. All right. So the first thing you'll probably see in your adventures as a freelance translator is a non-disclosure agreement. It's usually entered into when you need to show another party some sensitive information before you get into a real contract with them to buy or sell goods or services. It doesn't have to be long. It should be like a page, and it shouldn't overly burden somebody just to talk about doing business with you. It sets the tone for cooperative dealings. Again, if somebody gives you an NDA and it's 7 pages long, it's too long, and it's a clear sign that they're going to be difficult to deal with. An example, like just a simple example, is somebody's going to get into a contract to purchase cookies and they're going to sell them in their stores. The buyer is going to say, look, before we even decide if we want to buy your cookies, we need to know what's in them and how they're made. And then the seller is going to say, we don't want to show you our secret recipes, and then you can go use them without even getting into a contract with us. So they would issue an NDA, and everybody would sign it. And that way, if they didn't end up doing business with each other, their cookie recipe wouldn't be stolen. Now, how does this apply to translation? Well, I'm sure many of you have had this happen. Before you even decide if you want to translate your client's, say, patent document or something, you want to see it. You have to figure out, is it awful? How much am I going to charge? And the agency or the direct client will say, we can't just show it to you. It's proprietary information. You might steal their patent idea. So we need an NDA. And that's when one would be put in front of you, and you should look at it, make sure it's okay. And then you sign it. This is just so we can talk, so we can show each other our stuff and we can talk. These NDAs, or non-disclosure agreements, come in unilateral and bilateral format. Unilateral just means one way, and bilateral is two-way. And what that really means is, going back to unilateral, only one party is giving sensitive information. They're saying, again, with the example, we'll show you the patent and you have to promise not to share it with anybody. For the bilateral agreement, these are even a good idea sometimes, even if it seems like only one side is going to be sharing, because what it does is it sets the obligations for when the parties might be sharing information with each other, like two big companies going into a merger or something like that. They've got to share all kinds of stuff with each other. Oftentimes, an NDA will even say, you can't share the fact that we're even talking about doing business together, or you can't share the details of this NDA. It almost goes in a circle. It's crazy. But when you have the two parties, a good idea for a bilateral agreement is because if you insist on a bilateral agreement, even if you as a translator are never going to share secret information with the other party, it makes them kind of scale back on the obligations, because it won't, in general, the agreement won't be like one side is much harder than the other. There'll be mutual terms. The terms will be equal. So they won't want to burden themselves too much. Any more than they would burden you. I hope that makes sense. So when both people are subject to keeping secrets and the terms are kind of equal, it's a better, stronger agreement, and it sets a tone for a better long-term relationship. Now, that's where, you're going to just have a little agreement, and we're going to share some stuff, and it's not going to cover everything like payment and invoices and all that other stuff. It's just about sharing information.
Paige, can I interrupt you for a second?
Oh, yes.
I just had this question. What are the possible implications when you violate these NDAs? For example, you signed a non-disclosure agreement, and then you accidentally or purposefully disclose this information. What are the possible implications there might be for a freelance translator or a sole proprietor or a corporation?
That's a great question. There's a couple things that can happen, and I think purposely and accidentally probably have a lot to do with how bad things can be. It's pretty easy to tell if it's purposely or by accident, but I'm going to talk about it a little bit more in detail, but you would be in trouble for breach of contract, which could it be the court could award the other people whatever kind of damages, and you could have to pay whatever the court deems appropriate. Or you could have injunctive relief. Again, we're going to talk about that a little more, but they could say, okay, you've stolen this cookie recipe and now you've set up your own cookie factory. You have to close down your factory. Or they could you could be in trouble to a third party. Say you're working with an agency and you disclosed some very sensitive information, and maybe the third party is someone famous, and they're saying, "Oh my God, now I'm gonna have a lawsuit for slander or libel or interference with my privacy," something like that. So you really have to take these seriously, especially if you're dealing with sensitive information. Seems like lately I've been dealing with a lot of political stuff, and while it's interesting, you just can't talk about it with anybody, and you have to be really careful and make sure all your stuff is encrypted and all that. It's like sometimes I'll tell somebody later, "Oh, I worked on that," once it's all in the newspapers and everything. But other than that, really, you can't.
Paige, I also have a quick question. Are there any terms in NDAs, particularly for translators, that are can be somewhat unacceptable? Something like, I don't know.
Definitely.
Yeah. Can you give some examples of that? What we should pay attention to? So if we see something like that, we should probably negotiate.
No.
Yeah.
Yes, I'm going to get to them. Not too many, actually. I mean, I think for the most part, these agreements are and these sections are parts that they're well developed in the law, and there's so much back and forth that there usually isn't anything too unreasonable there. But again, there are some shady characters out there, so I will be hitting on those as we go through here. But yeah, definitely, I'm going to talk about what's normal. So if you see something outside this, and then I have some other examples coming up. Okay, so you kind of have an idea of what a non-disclosure agreement is. It could be one way, it could be two-way. It's saying we'll show you our stuff and you won't share it. Now, I'm going to talk a little bit about non-solicit agreements, and this isn't super common in translation, but just to keep you informed and to keep you from being confused, I'm going to go through a short explanation of what they are. Again, these are about like don't steal our people and don't steal our clients. And first, I'm going to talk about don't steal our people. Now, typically a non-solicit agreement will say, don't try to recruit our employees who you meet by virtue of your relationship with us away. Some of the wording you might see, and again, it might not say non-solicit at the top of the paragraph. You have to look for this. It might say during the effective period of the agreement and for X years afterwards, you will not interfere with the company's relationship or entice away from the company any person who at any time during the agreement was an employee of the company. That's pretty broad, but these are really serious. And we will discuss effective periods of agreements versus duration shortly. So back to non-soliciting. If the party obligated not to solicit, that's like us, does solicit someone away, like we steal a translator away and say, come work for, like maybe we stole a project manager and had them work and entice them to work for our cousin's translation company or something. That could be a big problem. And again, Dimitri, what we're just talking about, the violation is typically liquidated damages. It could be the injunctive relief. And I've seen liquidated damages in these situations be like 1.5 times the stolen worker's salary, which can be pretty high. The typical language might say, if you breach any of these provisions, the company will be entitled to injunctive relief in addition to any other remedies under the law. So if they feel they didn't get enough in the injunctive relief, they could still sue you for breach of contract and a whole bunch of other things. So it's just not a good idea to do. That leaves the dollar amount wide open. It can result in multi-million-dollar settlements. And if you're bored, not right now, hopefully, but if you Google non-solicitation damage award, you're going to find some incredibly huge settlements and judgments. So just be careful with that.
Paige, can I ask a quick question?
Yes.
You gave an example where, for example, you solicit a project manager that works for a translation agency that you're working with. What about freelance translators who might be working for this agency? Because from what I understand, technically, they are not employees. They are just contractors that work on a contract for an agency. So
absolutely,
is that considered solicitation if you hire a freelancer who works for the agency that you work with because you know him, you work on the same team, you know the quality of their work, and you might be willing to work on your own business together? Is that a
or even bring them to another agency? No, and this also ties into one of the things that we were just talking about. It's one of the great things about being a freelancer is you're free and you're able to work for whoever you want or not work for whoever you want. And the law, at least in the United States, and I think most places, really kind of respects a person's right to make a living, and they don't want to restrict it unnecessarily. So, you know, it's appropriate sometimes to have a non-solicit agreement, maybe between agencies, but it's, you know, the whole essence of our worker format, so to speak, is to avoid those restrictions. And so chances are that there wouldn't be a problem if you like stole a freelancer. Now, if somebody would like, if you stole away an agency employee and got them to work for somebody else, that person who got stolen is fairly immune from any kind of lawsuit or any trouble or anything like that. But the person who enticed them away and also the place where they went to work, they could be in big trouble. So just stay out of those situations. But in terms of us as freelancers, we're pretty free. So
good to know.
Another benefit. Yeah, I mean, if you and I were chatting and we both work for X agency, and then you also work for Y agency, you could tell me, hey, I only work for X when Y doesn't give me any work because Y is nicer and they pay better or whatever. You know, I'm not giving legal advice here, but based on that tiny bit of facts, there wouldn't be a problem. You know, of you saying, hey, here's my favorite PM's number, talk to them, see if they'll bring you on board. So again, these things aren't really going to happen too much in a freelance translation environment. But you know, when you get into, if you have your own agency, you don't want to steal people, you know, employees, or if you have two agencies and they're doing a deal together, you really have to be careful not to entice people away or entice people into somebody else's company. But independent contractors, freelancers, we're pretty safe. So the other kind of non-solicit agreement is like, it's pretty simple. It's don't steal our customers. And again, this is not usually going to apply to us, but it's going to say something like the vendor will not, and they'll make sure their employees don't enter into any business relationship that competes with us. They won't sell any products in competition with us, and they won't divert any business away. It's pretty simple. Don't steal our clients, don't compete with us, and don't let your workers do it either. And again, that's, you know, I mentioned these non-solicit because it's bunched in there with non-disclosure. But if you see this stuff in, just like we were just talking about, Elena, if you see this in an agreement, it's so highly unlikely to be applicable to us. You might want to strike that part out and say, you know what? I'm a freelancer and I don't own an agency, so this doesn't apply to me. So can we just strike it out? It's not super harmful to leave it in, but if it doesn't apply, it's better to get rid of it. So, you know, it may just be their standard agreement for everybody, but they may want to think about scaling it back for freelancers. It just makes them easier to deal with. Now, talking about non-compete agreements, this is another thing. This may or may not be applicable, and this is something you should look out for. Elena was just asking, and stay away from. So, for a little background, these used to be a lot more common in the United States and more enforceable. They're becoming less and less enforceable in the United States as time goes by because of that concept I talked about, where the law respects people's freedom to work, and they want you to be free to work in any place you can. They don't want to say, okay, once you've worked for this one, I don't know, bread company, you can never work for any other bread company, you know. So chances are, again, if you're a freelancer, you're not going to be asked to sign one of these non-competes, but if you see language like this in there, then you might want to push back. So again, the entire notion of freelancing and independent contractors is we're free and independent from any one employer. Ooh, I see a question. Okay, let's see.
Yeah,
Okay, Amaya, that's good.
Let me read it out loud because we might have this in the recording and not everyone will be watching this, but probably listening in the podcast version.
Oh, the
kitty. So Amaya asked, what if one agency that you work for has one client and then another agency offers you work for the same client? So this is what my ask.
Good question.
Okay. It's a great question. What you need to do is look at your contracts for both of your clients and see what they say. Now, it shouldn't say anything about once you've worked for one client through us, you can't work for them through anybody else. You shouldn't agree to any language like that. And I hope they didn't ask you to do that. But I think your instincts are good, Amaya, to say, hey, what's going on here? Check the language of your contracts. And if you're not sure, check with an attorney or, ask both of them, hey, is this okay? You don't want to really rely on their advice, but it's probably okay. But I think that's a really good question. And I'm glad you brought it up. These are the kind of things that, they raise a flag, but in that context, it's probably okay. It just depends on what your agreements with both companies say. So let's see. I'm going to talk a little bit more about the non-compete agreements just for a moment. So such agreements, they usually were limited to restricting former employees from going to work for a competitor after they, put their time into training them, and they wanted them to not go to somebody in a similar geographic area and then take over. They knew all their secrets and everything. But today, non-compete agreements, they're becoming less and less enforceable. In fact, and also more narrower and narrower. They've been in some states in the United States, it's only officers of a company and things like that. So in California, they're virtually unenforceable at this point. And a lot of other states, it's just a very, very narrow circumstance. So if you see something that restricts your ability to work for somebody else, then question that and take a look at what the contract says. And I would push back on that. Today in our global economy with our easy distribution, our ability to deliver our services virtually anywhere in the world immediately, and our ability to advertise anywhere, this geographic restriction, which used to kind of balance people's right to work with the company's investment in an employee, it doesn't really apply anymore. So if you do see any kind of non-compete, I would try to back away from that. Now, I'm going to move on to confidentiality. This is the big one, and we'll probably spend the rest of the time talking about this. Again, the NDA, it's like a baby confidentiality agreement. It's just like, okay, we're going to share our stuff and we're going to talk, but we're not going to establish any terms or anything yet. This is just so we can show you our secrets. Okay, now you're in an agreement. Okay, we like each other. We want to do a deal together. Normally, the confidentiality part is a section of your service agreement. It's not going to be a standalone agreement anymore. Sometimes the NDA is subsumed into the service agreement, but usually they'll say something like, all the other agreements we had with each other are now null and void and we're starting over. And there'll be a huge section about confidentiality in your service agreement. Sometimes they'll say everything from the NDA still applies plus all this other stuff. So the baby agreement kind of goes away, and now you have like a big mama agreement. It's usually one of the largest sections of the agreement, and that's also specifically true when you're dealing with companies where their business focus is on valuable and confidential information, like if they have patents, if it's intellectual property, if it's trade secrets, proprietary software. I'm thinking of you, Dimitri. Those guys have with the gaming people, and anything with software is so important not to share. So they care very much about this, and they'll hold you to it. They'll hold you to keeping it a secret. So a typical confidentiality provision within an agreement will discuss three things. One is what kinds of information actually constitute confidential information. Another is what the parties can and cannot do with the information. And three, how long does this obligation last? So what constitutes confidential information? First, the parties usually describe some specific types of things that can be considered confidential information. And of course, they'll say including but not limited to, or by way of example, but not limitation, something like that. Certain things they'll usually talk about are financial information, and that's going to be things like profit margins, their expenses, their revenues, their forecasts. And this is especially important to companies that are not publicly traded. If these companies are publicly traded, they're usually, this information is out there in the public. In the United States, they have to send everything to the Securities and Exchange Commission, and it's public. So you can go look up, what condition the company's in. Now, we also have private companies. They're not traded on the stock exchange, so they can do whatever they want behind closed doors as long as it's legal. So they're going to really hold on to their financial secrets. So other information is just like everyday business information, which could be things like trade secrets, software, source code data, business plans, joint ventures that they're thinking about getting into, all that kind of secret business stuff. And they'll also mention the terms and conditions of the service agreement, or even the fact that they're doing business together at all could be held as confidential. And then they'll also talk about the format it's in. Is it going to be electronic, writing, orally? And they'll usually have a paragraph that basically encompasses everything but telepathy. So you'll have some really broad language there. Now, there's some exceptions. The language is so broad. It's like anything, if it's a paper, if it's a model, if it's software, but there are some common exceptions, and they're pretty much always the same in every agreement. You'll see confidential information shall not include information that is publicly available, was already known to the recipient at the time of disclosure, is independently developed by the recipient, like some kind of engineering thing or something that they also can develop on their own. And then, excuse me, something that the recipient got rightfully and legally from another party. Or also that the disclosing party agreed and gave them permission to disclose. So, for example, they're giving you their secret recipe for something, and they say, okay, you can give this to your subcontractors to go and help you make more cookies or whatever. So after they talk about what is confidential information, all of those things, the next thing they talk about is, what are your obligations? What can you do with it, and what can't you do with it? Because they're giving it to you, you got to do something with it, but there's a whole bunch of things you can't do with it. And normally they say, you're receiving this information, it's considered confidential. And the common language that I see a lot and that I actually like is where they say the recipient promises to keep the information in strict confidence, and that they will treat it like they would their own information. So again, there's a little bit of fairness in there. They're not expecting you to keep it in the strictest. They'll say strict. Now, the reason you want to avoid strict-est or any kind of extreme language like that is, what is strict-est? Do you have to build a vault for it? Do you have to put your life before you would, just stay away from absolutes. And strict is fine. Strict is reasonable. But strictest or anything est or whatever, or to the utmost or anything, stay away from that kind of thing. If you see that sort of thing, try to fix it, back away. If you have a lawyer, ask them for help, or, maybe look at another agreement and look for softer language or something like that. But these people will try to get away with what they can. Most of the time they think that no one's reading the agreement, which sadly is true. But if you do take the time to push back, I've found, and this is even without them knowing that I'm a lawyer or anything, I've found that they say, okay, if you ask nicely, if you don't go, your contract is crazy and ridiculous, who do you think you are? If you say, yes, I really like it, but could you please remove paragraph 2 of number 9 and do the work for them, they'll be much more likely to agree. If you do it for them, you say, please change paragraph 9, get rid of the second sentence so that it would now read blah, blah, blah. And, they want to keep moving forward too. So if it's at all reasonable, they'll probably say yes. Okay. Now, anybody have any questions? Let's see. No, we're doing okay so far. Okay. So now we're going to talk about what you can do with the agreements and what you can't do. So again, with the strictest thing, stay away from absolutes, and it's okay to agree to treat it as you would your own proprietary information. They may say that you're allowed to use it only for the duties, for performing the duties of the agreement. They might say no purposes other than things directly related to your performance of the services under the agreement. Or they may say things like for their exclusive benefit, which I don't love it, but it's okay. Also, if you have employees, they might say that you have to require your employees and your subcontractors to adhere to the obligations. They might say, another thing that you'll see, which is kind of okay, I think, is they might say you can only share this with people within your organization that have a need to know. Let's see, need to know. And that's usually okay, because you don't want to share it with everybody. Don't share it with every Tom, Dick, and Harry. Only those, you're just increasing your own risk of a breach of contract lawsuit. So just give it to the people that need to know to use it. And then there's an exception to this. And so let me just give you an example. Suppose you have some secret information. You've signed the confidentiality agreement. You've signed the service contract, and there's a confidentiality section in it, and you're trying to obey it. And then all of a sudden, I don't know, that company you're working with, they're in a big lawsuit with somebody else, and the court calls you, or they send you a subpoena, and they say, hey, you have to turn over that secret stuff they gave you. You're like, crap, what do? I don't want to get in trouble with the court, but I don't want to have a breach of contract case. You'll see some language that says, well, it will basically say it's okay to disclose it to the court upon a court order, but you have to at least let the other side know that happened and give them the chance to fight it. You don't want, if the court doesn't give you enough time, there's nothing you can do, but you have to give them the opportunity to fight that court order. Or it might say something like give them the opportunity to oppose it or something like that. So that's a big exception. You're not supposed to share, blah, blah, blah. But if the court comes down and says you have to share, you do, but you may have agreed to give them the opportunity to oppose it. So, just read this section someday when you have nothing else to do. Read these sections carefully. Oh, I've got a great question here.
Great question from Tracy Peel in the chat. What about if you need to pass on the info onto your reviewer or proofreader?
That's a fantastic question. And that goes back to if you're requiring, remember we talked about the cookie factory or to your subcontractors. Mm-hmm. You have to get them probably in the agreement. You've probably agreed to get anybody that you share this with in the process of fulfilling your obligations under the agreement to also agree. So you want to have in agreements with your proofreaders or whomever really, really strict terms. And you could even put something in there that says if you give them confidential information, they have to agree to whatever terms you've agreed to. They may ask to see it, which I would, and that's reasonable. But when you start dealing with subcontractors, the concept is they call it a flow down, and that means all the terms that you've agreed to with this party up here flow down to the subcontractor that you're dealing with down here. So it's very difficult, and you have to make sure that you're really meticulous about making sure that if you agree to something, especially something unusual or unusually strict, that you carry that through to anybody below you, so to speak, who works on this project. So it's a good idea to have a lawyer.
But do you have to inform the client that you are going to pass on their confidential information to a proofreader or reviewer?
That depends on what your contract says. You may have agreed to that, or you may not. You may just agree to make everybody who works for you adhere to the same rules, or you may have to notify them. You may even have to get their consent. Mm-hmm. So it really depends on what the contract says and what you have agreed to. Obviously, if you haven't agreed to anything yet, you want to make it as easy on yourself as possible and just say, yeah, I'll make sure that they are as secretive as I am. But, you may have agreed to get their consent or whatever. So be careful if you're thinking about sending something to a friend to work on. Mm-hmm. But these are fantastic questions. I'm so glad you guys are asking them, because this is the stuff that comes up, and, it's like a red flag. I'm going to give this to somebody else. It's only for work. I'm getting it proofread, but I promised I wouldn't share it with anybody. Is this, not allowed? So just, check your contract and try, before you sign it, try to negotiate. Hey, Elena, where'd you go? Try to make it easier on yourself, less burdensome. You still there, Elena?
Yes.
Yeah, we'll probably have some connection with the video, but we can.
Oh, okay.
Okay, as long as you can. Okay. So let's talk a little bit about how long this obligation is going to last. And this is something really confusing. And I really just got my head around it, I think 10 years ago. When you have we'll call it a confidentiality agreement or the confidentiality obligation, there's two time periods that you need to be aware of and understand. And I hope I can explain them well here. One is the term of the agreement, and one is the duration of the obligation. So you have the term of the agreement and the duration of the obligation. The term of the agreement is talking about the effective period of the agreement. So like a typical non-disclosure agreement, it's signed by the parties who just want to share information before they can decide if they want to do business together. It might be valid for 90 days. That's typical. Nothing ever really gets done that quickly, so they usually renew it a couple times. But once they do sign a service agreement with each other, the NDA is usually recognized and subsumed, like we talked about. But if the parties walk away from their negotiations and they don't end up entering into a service agreement together, what do they do? Well, after the 90 days, say on day 91, that doesn't mean you can start sharing their stuff. There'll probably be a clause within the agreement that says that the duration of your obligation is longer. And what I mean by that is like the other date is the duration of the obligation not to disclose the information after the expiration of the term of the agreement. So whether it's 90 days, whether it's 3 years, your service contract or what, once that agreement ends, your obligation to keep the secrets doesn't end. Pretty much everything else does, but not that. So in our example, the parties let the 90-day agreement expire and they don't enter into a business agreement. They must continue to treat the information they received that's confidential as confidential. Any information obtained during that time period. So you've got the beginning of the agreement, the end of the agreement, and in the middle is when they shared information. Anything that they gave you during that time is the stuff that you need to keep a secret. And the duration is, it will be written into the agreement, but we're going to talk about how long that is. It might say something like, notwithstanding the termination of the agreement, each party's duties with respect to the other's confidential information shall continue for X number of years after the termination of the agreement. Another thing you might see, not as often, is X number of years from the date of disclosure of the agreement. I like end of the agreement because it's easier to keep track and easier to prove. It's like, when did I get this? It's a lot easier to prove when the end of the agreement was because it's in writing all over the place. So how long can that additional period be? Okay, if you're the person who shared the information with a potential business partner and they don't end up doing a deal with you, you might reasonably want to keep that information confidential forever. You didn't even do a deal with them, but you showed them your secret stuff. They better not tell anybody. Well, the law doesn't really like to put that kind of extra long-term burden on a party. So they kind of, a good rule of thumb is 1 to 3 years, but they also look at the type of the agreement. For example, it could be something like the Coca-Cola recipe, which is a trade secret. You can never share that, or you'd be in big trouble. If it's something like, the only example I could really come up with is, suppose you had a list of the names of the upcoming Golden Globe Award winners, right? Once the Golden Globes are over, it's not a secret anymore. It's quickly, say it's the next month, then you don't have to worry about it at all. So starting at the end of your agreement with them until the Golden Globes are over, then that's how long you have to keep it a secret. But if it's something, it could be indefinite, or it could be just a really long time. Like it could be how somebody operates their business, and it could be a unique or slightly different way they operate their sales scheme or something. And you might need to keep that a secret for 3 years. It's like the information, the confidentiality or the proprietariness of the information can kind of get stale, so to speak. And then it doesn't matter. Everybody knows that now, but initially it's really important and valuable. The secretiveness of it is valuable. So to summarize this term and duration thing, a non-disclosure agreement or confidentiality provision in an agreement, it has a term, and any information received during that term falls within the obligations of the agreement. Anything they gave you before you had an agreement with them doesn't count. Anything they gave you after the end of the agreement doesn't count. But there's an obligation to keep things a secret for a certain period of time after the agreement has expired. I hope that makes sense. Just to try to round it out a little bit more, the agreement's 3 years long. You have to maintain the confidentiality of any agreement disclosed to you during that 3 years until the agreement expires, and for 1 to 3 years afterwards. So I hope I've explained these time periods, term and duration, well. It can be very, very confusing, and I even had to draw myself like a little diagram to get my head around it. So even though your agreement with them is over, you don't work for them anymore, you might be obligated to keep the secrets for a longer period of time. All right, just a couple more things, and then I'm just going to open for questions. Now, there can also be another obligation upon the expiration of your agreement with somebody, your confidentiality agreement or your NDA. Again, this is something that, you know, with modern technology, it's kind of fascinating to me because I came into law and being an adult before the existence of computers. We had typewriters and things like that. So watching it evolve is just absolutely fascinating. And in the old days, we would say that upon expiration, any of the secret stuff that you have to destroy it or send it back. And it might say upon request, it might be send everything back. You might even still see this language I have in translation agreements. And I'm thinking, first of all, everything that goes over the computer is clearly never destroyed. You know, we know that just by watching the news. And then like sending something back, that just puts it at more risk of someone else seeing it. You know, whether you send it in an envelope in the snail mail or whether you transmit it back to them, it just it goes through the internet again and opens it up for more vulnerability. So, you know, this is the kind of thing that you don't see as much anymore. And if it's me and I'm looking at an NDA, you know, this might not be right for you, but for me, if I see them, you know, obliging me to get rid of something or send it back, I say no way. I say it's too big of a burden for the money I'm making off this, or for the money that I'll make working with you. That's too much of a burden, so I don't want to do it. And usually they say, okay. I mean, if they don't, I just won't work with them because that's too much. And how could I be responsible for it being destroyed when nothing's ever destroyed? I mean, do I have to take my laptop outside and burn it? You know, it's in the cloud somewhere, so forget it. So just to go over everything I've talked about really quickly, in general, because these terms have different meanings depending on what it says in the contracts that you've probably signed or that you will sign. A non-disclosure agreement, it's usually like a mini agreement addressing only the keeping of secrets. It's intended to be for a short period of time while you figure out if you want to do a deal together or not. It facilitates sharing sensitive information without having to go through months and months and months of contract negotiation, which is what happens in big corporations. You know, it's just like, okay, we promise we'll keep this a secret. Okay, good, we'll show it to you. That's it. A non-solicit agreement is don't steal our people and don't steal our clients. A non-compete agreement, again, it's practically unenforceable in the US, especially for freelancers or independent contractors, but it keeps people from being trained at the expense of one employer and then taking their skills to another competitor. And now the biggest piece of this is confidentiality itself. And it's the section of an agreement that describes the types of information that need to be kept secret, the obligations of the parties, any exceptions and penalties. And then lastly, again, the two important time periods are the term of the agreement, which, you know, limits the information covered by the agreement to information shared during the term of the agreement, usually. And then the duration of the obligation to keep it confidential, which usually continues from the disclosure of the information or from the termination of the agreement to some certain period of time. So I would go back, if you've signed a bunch of agreements and not really looked at them, I would go back and look at these sections and get your head around what your obligations are, and just be extra careful when you're sharing, especially like Tracy's question about, you know, sharing it with a proofreader. Make sure you don't just send it to your friend to look at. Make sure that they agree to your the terms of whatever you've agreed to. look at the agreement and see if you need to get permission to send things out to proofreaders, things like that, before you move on. I think, this language it can be very confusing and scary. And when I see something I don't understand, I kind of just shut down at first, but then it's important. So you have to kind of like lift that veil and dig in and look at it. And hopefully this webinar has given you enough of an explanation in human terms so that you can go back and look at your agreements, or the next time you get one and say, hey, I know what that means and I don't like it, or oh, that's okay. That is all going to be up to you, your situation. I'm not your lawyer, but now you kind of hopefully know what you're looking at and you can understand it a little better. Do you guys have any other questions? I'd love to hear them.
I have a question regarding what you've just said. So let's imagine a situation where our viewers and listeners have listened to this webinar, found this useful, went back to their agreements that they have signed and found something quite awful there. Is there anything they can do about it now?
Yeah.
Once they have signed
Absolutely.
it? Mm.
Yes. I think that they can go back and renegotiate.
Mm.
It's not unheard of. The other side isn't going to like it, but if you ask nicely, they need, don't forget, you guys, just in a bigger and broader sense, they need us. Okay. So we have power. And don't forget that, none of us are groveling. We don't have to. And if you're thinking that at all, don't, because they need us. And I have found agencies and direct clients so willing to negotiate as long as you ask nicely. I even had a person, in the first time you hear, you get your answer, they might say, oh, I'm sorry, that's our standard agreement and we just can't vary.
Yes, that's a standard reply that translators often get from agencies when they try to negotiate.
Of course.
Yeah.
Yeah, no, that's just, first round. That's like, okay. You go and you say, oh, okay, I totally understand. Could you please pass my request on to someone with the ability to make changes in the contract? And that might sound kind of mean, but what are they going to say? I mean, if they don't do it, you can go to their superior and say, hey, they never did it. And I've even had them change the programming in one of those click to agree things because I didn't want to agree to something. It was absurd. And they changed the click to agree thing for me. So just because it's programmed in the computer doesn't mean you have to agree to it. And I think people should go back more and more and more and try to renegotiate. If you see something in there, you want to keep working for this company. They're great, they're nice, but there's something in there that really scares you. Like, oh my God, I could get in so much trouble and it probably wouldn't even be my fault. You can look at that and you can say, hey, I was just looking at our agreement and there's something in there. I know I signed it back whenever, but, also look at the dates. If it's about to expire, something like that, it's a great time to renegotiate. But you can renegotiate, I would say, really nicely. Do you mind if we remove this second sentence from paragraph 9 and then it would read whatever? And I would say 60% of the time they just go, okay. And then another 15%, they say, I'm not sure, I have to work for it. And then maybe a few of them say no. And then if they're that inflexible, just stay away. You don't want to do business with them. There's too many clients out there to deal with anybody that's going to treat you poorly.
Yeah, absolutely.
So I think we have negotiating power, whether it's rates or whether it's crappy contract terms or payment methods, whatever, as long as you're nice about it and you ask respectfully, you can get pretty much anything you ask for.
That's a very great approach.
It took me a while to get there. At first I was like, ooh, thank you for the work. But then I thought, okay, they really need me right now. So this is, oh, hey, Elena's back.
Oh, you can see me now, right?
yeah, we can see you. We have not a question, but rather a comment from Sue. In the UK, our professional organization's code of conduct seek to make us liable for our subcontractors. And I think that this is worrying and also difficult to do and to police. So I read this comment and I had a question. Is there any way to limit your liability for the actions of your subcontractor in front of your end client, for example? Is there a way to sneak in some sort of a provision in the contract saying, hey, I'm going to outsource your work, they're going to keep the confidentiality, but if they mess up, don't blame me?
In general, no, because so you have the main client. I'm just going to give a typical example. You have the end client, and then you have maybe an agency, and then you have a translator, and then the translator has like a subcontractor or of some type, whether it's another translator or a proofreader or something like that. You can't really just completely remove liability from yourself. You can, you can do it with your contract, but it's not a great way to do business. You have to accept some responsibility, and usually you're responsible for anything below you. In terms of the person above you, you have to answer to them. Now, you can go back and say to the person below you, okay, you messed up and I had to pay, so now you pay me. But you can't just cut yourself out of the middle and tell the guy above you to talk to the guy below you, in terms of the contract. You can, but you're not going to be in business for long if you do that. It's just not a great way to do business. Now, what were you saying at the beginning? It's someone's code of conduct?
As you, from the comments, she was mentioning that in the UK, professional associations have these codes of conduct, and they try to make them liable for our subcontractors. And she says that it's very difficult to police and to be liable.
I can't really speak for the UK, but I know that codes of conduct in the United States are not contracts. So while you might get kicked out of the association or something, if you violate it, you're not bound legally to do it. Now, it is difficult to police, but as a business person, you have to do that. And when you outsource, you're giving up a certain measure of control, whether it's confidentiality or quality or anything like that, delivering on time. You have to find subcontractors, you have to vet them, and you have to find ones that you can trust. You really have to vet them. I work with a lot of lawyers who are also translators, and although the vetting process is difficult, it's worth it. It's just like finding a tenant for your house. If you're renting a house or property or something, do a background check, do a credit check, do a criminal check, make sure they haven't been sued for not paying their rent before. And all of that is time and money. But then when you have a tenant who pays their rent and doesn't break anything for 4 years, you're so happy. So really, as a business person, it's up to you they're acting on your behalf. So you have to vet them, you have to figure out if they're good or not. And it's a risk. But if you put the time in at the beginning and you vet them properly, then normally you're okay.
Can you give any tips on how to vet your subcontractors?
Well,
it's probably a topic for a different webinar.
I love talking about this stuff. What I do is I just don't take their word for stuff. I get their copies of their law degrees and their registrations that they really are lawyers. I get samples of their work. I don't make them take a test because I don't speak all those different languages. And it's just I give it to somebody else, and then they say it's good, they say it's bad. I look for samples, and I do have people evaluate the samples. I get copies of their transcripts, copies of their registrations or their certificates or whatever they have in their country, copies of their diplomas, and a certificate of good standing, which means, I graduated from law school and I took the bar, but I also haven't been disbarred. I'm not in trouble with the bar. So it's a lot of legwork, and people don't want to do it. But once I've got all that stuff, I feel pretty secure. But also, I start small when I'm subcontracting things. I send something small to somebody before I send them a 50,000 word job. If they screw it up, I'm in big trouble with my client, and it hurts my reputation. And you just don't want that to happen at all. So I start with the 500 word project, and then maybe 1,000, and see how that goes. And if they start showing me that they work well, then they get the big ones.
Speaking about responsibility, I know that some agencies now require their freelance translators who are basically subcontractors to have a professional insurance. Isn't that trying to push their responsibility to translators who they work with?
Oh, I think that's a great question.
What do you think?
God, we could do a whole other episode on that. Well, I require people to have insurance, and I have it. I love insurance, though it helps me sleep at night. I'm a risk-averse person. Other people are like, whatever. Yeah, we could talk about this. There's a great conversation in prose somewhere about people that like having insurance and people that don't, and that's it. There's some good points on there.
I understand that the necessity of having a professional insurance when you are working with direct clients, absolutely. But when you are getting work through agencies, and when an agency requires a translator to have an insurance in order to work with them, I'm not sure that's not about trying to
shift the liability.
Yeah.
Well, I disagree with that. I mean, I can see how you might think that, but they have insurance too, right? But you know, in the end, so again, the example with the oh gosh, it's getting so late. I'm sorry. The example with the end client, and then an agency, and then a translator. It's not like the contract will still hopefully hold them reasonably liable. It will hold them liable for anything they screw up, and they won't, you know, totally again cut themselves out of the liability picture, and they won't shift it all onto you, because you know, you are not their insurer just by doing a 10,000 word job for them. That doesn't put you, you know, they don't pay you enough to take on all the liability that could happen.
Exactly.
A mistake, right? But mature and grown-up businesses have insurance, and they require others to have insurance. I know it's kind of late, but I just want to tell you a quick little story. There was, when I worked for Bacardi, they have a very extensive art collection, and we needed a painting to be restored. And we had this artist who actually was an assistant working on the original painting, working on the restoration. He was just some guy in his studio, and I insisted on having insurance, and he didn't have it. And we kept going back and forth, back and forth, back and forth. And I'm thinking, wait a second, we're paying this guy like $50,000 to restore the painting. It was a multi-million-dollar value, the painting. And I thought, you know, why don't we just pay him a little bit more, and he can go out and buy insurance? So that's kind of what we did. You know, I said, look, if we give you more money, will you please go buy insurance? And he was like, yay. And then he was insured for, you know, the rest of the year on his other projects too. So, you know, it's just something reasonable to have. It depends, you know, again, we could do a whole show on this, but I think it's reasonable to ask people to have it. You know, and also it depends on what country you're in, whether it's customary, whether it's available, whether it's affordable. In the United States, it's super cheap. It's like under $200 for, you know, for a freelance translator to get a small amount of insurance. You know, and the language of your contract and the way you structure the liability part has a lot more to do with how you protect yourself than insurance. You don't ever want to use that insurance. You know, you don't ever want to have to use it. You want to look at your contract, and you want your contract to say, yeah, I messed up, but look at the language in the contract, so I only have to pay whatever. And again, we'll talk about, gosh, we need to have another talk about
Good idea.
Next season.
You're always welcome back.
Yeah, but there are ways to protect yourself. And the important thing is that you guys are thinking about these things, that you're asking these questions, and that you're looking to protect yourself, because you're thinking about the future, you're thinking about your business, and you know, there are things you can do, and it's worth the time to put into tweaking your contract language a little, reading things before you sign them, getting advice from a lawyer. I know it's expensive, and I apologize for that, but it's worth it. It's the same with getting a professional accountant. That's very expensive too, but it's worth it. You don't want to deal with the problems later. You'll sleep at night. And so I'm really happy that everybody's so active with their businesses and protecting them. So does anybody have any more questions? I think I see one.
Yeah, we have a question from Valeria. Is the freelancer liable to the agency for E&O or only the agency to the end client? I'm not sure what E&O stands for.
E&O is errors and omissions, and it's the name of a type of insurance coverage, and it's just one coverage that's possibly applicable to translators. There's all different types you can get, but that answer, Valeria, depends on what your contract says. It could be you, it could be them. You know, they're all different types of contractual language, but look for words like liability and indemnification and see what it says. If you don't understand it, ask somebody who does, and you may need to renegotiate your contract. But it's well worth the time, and companies are much more willing than you would imagine to renegotiate contracts.
Okay, I think that's all questions answered. Thank you very much, Paige, for such a useful webinar. I hope that you guys have now more understanding of what the different types of contracts and agreements mean, what implications they have, and I hope you found it useful. We'll probably see Paige in our next season with a webinar on insurances and protecting ourselves as freelance translators. Yeah.
You know, I'm out there on Facebook. Just reach out to me if you have a question. If I can't answer it, I'll let you know. But if I can, I'll be happy to.
Great.
Yeah. And please don't forget to share this episode with your friends and colleagues who couldn't join us today. Also don't forget to check out our sponsors' website at smartcat.ai, or just by clicking the green button below or the first link in the description if you're watching this in the recording. And don't forget to visit our website at translatorsonair.com and subscribe to our mailing list so that you won't miss any future episodes. We have quite a bunch of them lined up till the middle of July now, and we have a lot of useful webinars coming. So thank you for joining us tonight. Thank you, Paige.
Thanks, everybody. Bye.
Bye-bye.
See you next week.